Hello, everybody. I wanted to do a series of a couple of podcasts on estates and inheritance. These are informational podcasts. I'm not trying to solve any problems here, change any laws or the Constitution. Um, just wanted to try to inform you of what the actual laws are involving inheritance of estates, particularly in the state of California. You should know that inheritance laws, by the way, vary from state to state. They're very state specific. So, inheritance laws in California are quite different than inheritance laws in most other states. Um, so, a lot of what I'm going to be talking about today, at least some of it, is only going to be relevant if you live in California. I know some of you may live in other states or even other countries where the inheritance laws are quite different. And so in that case, only some of this and maybe almost none of this will apply to you. So if you're not a California resident, you should definitely take everything I say here with a grain of salt, because it just may not apply where you live. But some of it will. There are certain things like trust accounts and probating of wills that, although they may vary in detail from state to state, are fundamentally the same in different states. The reason I want to take on this, I wanted to do this set of podcasts, is because this is a topic like no one wants to talk about, because it involves, basically contemplating your death. And that's not something most people like to do. So because people don't like to think about this, oftentimes it's a neglected part of our financial planning. And I have to tell you that recently I had a very difficult situation with my father's will, and it led to a lot of family conflict and tragedy. And I don't want to see that happen to anybody else. So I think the best way of ensuring that things go relatively smoothly and according to your wishes after you die is to create a will or a trust while you're alive, so you can specify what of your estate goes to whom, and how much everyone gets, and it just makes the process much smoother. You should know that distributing assets according to a will or a trust after someone dies is never easy. This is a difficult job, even with a very, very good and well-written will or trust. It's still a difficult and time-consuming job for whoever is going to administer it after you pass. But still, it's much better to have it clear, so to minimize conflict, because this is the kind of thing, as I saw firsthand, that can create tremendous conflicts within families after someone passes. And if you don't want to create lots of drama and conflict in your family after you die, then one of the best ways to avoid that is to have a nice, clear, and concise will or trust, or both, governing the distribution of your assets when you die. So I know you don't like to think about this. No one really does, but it's an important thing to think about for the sake of family harmony, and also making sure that your wishes are honored after you pass on. So for the purposes of this topic, I want to define some terms like an estate. Okay, so what is your estate? This is what gets distributed after you die. The estate is basically everything you either own or co-own. And that's all the way from little stuff to big stuff. So your estate does include your personal items at home, like your clothes and furniture and electronics. It also includes any real estate you may own or co-own, vehicles you may own or co-own, like a car or a boat, bank accounts that you own or co-own, investment accounts or investments that you co-own or own, like stocks or bonds or mutual funds. So all of that stuff, if you are a full owner or a part owner, you is part of your estate. And that's what, after you pass, we want to distribute to other folks. Now, a lot of people these days are not writing wills or trusts, so they're not setting up their wishes in a legal sense before they pass. And, we'll go over what happens when you do that or when you don't do that. If you fail to set up a will or a trust before you die, then the distribution of your estate goes under what's called the rules of intestacy, which are actually different in each state. But in California, basically it's this. If you don't set up anything, then if at the time you die, what happens to your estate depends a lot on whether you're married or not. If you are married, if you have a spouse that survives you, they get all the household stuff, and they get half of everything else that has value, like accounts that are just in your name or property that's in your name. If you have accounts and property that are in both of your names, then they get all of that. So if you have like joint bank account, they get the entire joint account. If you own a home jointly where both your names are on the deed, then they get the entire home. Your spouse does. So if you have a spouse, they get everything in the household, and you don't have a will here. They get everything in the household. They get everything that's jointly owned, all of it. And then everything that's left over and they get half of all of the additional stuff that's left over, and then like accounts, bank accounts. And then the remaining half are distributed among your closest living relatives, starting with children if you have any, or parents if you have any. Personal property in the home, if you're married, just sort of automatically goes to your spouse. Like they get the furniture, they get the clothing, they get the jewelry, the electronics, unless you specify otherwise in a will or a trust. But I'm assuming here there is none. So they get it all. If you die without a spouse and you don't have a will, then your personal property goes to your closest surviving relative, whoever the court determines that to be, usually a child or a parent, or a brother or sister if there's no child or parent. So they get your personal stuff, and then all the other stuff that you may own is sort of divided up among them and your other relatives. So that's what's going to happen if you die without a will and without a trust. Now, maybe that's what you want to happen, or maybe you just don't care, in which case, fine. But one thing you should know is if no close surviving relative can be found of yours, let's suppose you have, when at the time you die, you have no children, no spouse, no parents, no first cousins that can be found, no brothers or sisters, then your entire estate can go to the state. The state can actually confiscate everything. And let's suppose that you die and you have a partner, like someone you're living with, but you're not actually legally married to them. They can't get your stuff if you die without a will. If you die without a will, then your stuff goes to blood relatives. So even if you've been living with your partner for 5 years and you're deeply in love with them, you die without a will, all of the stuff in the household where you're living together goes to your closest blood relative. maybe a parent or a child or a brother or sister. Your partner gets nothing. And that's also true of other assets that are not co-owned. So if you don't actually legally co-own, say, a bank account or something, then all of the money in your accounts goes to your closest living relative, or is divided among close relatives. Your partner gets nothing. That's the law. So, for example, if you have a partner that you care about but you're not legally married, then you better write yourself a will or a trust to make sure that they get some stuff that you want them to have. And maybe, assets that you want them to have too. Otherwise, they won't get nothing. Okay, so hopefully I've convinced you that this is important, because dying without a will or a trust, intestate is what they call it. That's, everything is out of your hands, and legalities dictate that it's your closest living blood relatives that get your stuff and your money. So if that's not what you want to see happen, you need the will. Okay, so some other questions. Let me answer a couple more questions that people tend to have about what happens to their stuff after they die. Let's suppose I die with some debt. I mean, most people have at least a little debt when they die. Do my beneficiaries have to pay off the debt? So now we're supposing we have a will. But this is true actually even if you don't. So if you die with some debt, do your beneficiaries have to pay the debt, whether or not you have a will or a trust? And the answer is yeah, they do. But only to the limit of what's available in your accounts. So technically, after you die, what's paying off the debts that you owe is your estate. It's not you, your debt. It's the estate that you have. That's all those assets that you have. That's what's paying off the debt. But the debts, legal debts, we're talking about legal debts now. Legal debts have to be paid off before beneficiaries can be paid. When we're having an inheritance situation. So anybody, any entity that you owe money to that's legal, like a bank or a hospital, they're going to want their money, and they're going to try to get it from your estate, and legally they can get it from your estate. Now, they can't get, in most cases, no, not all, we'll talk about exceptions, but in most cases, they can't get more from your estate than your estate has. So let's just do some real scenarios. Let's suppose that my estate, the value of everything that I actually own or co-own when I die, is $200,000. But let's suppose that before I died, or at the time of my death, I actually owed banks and various other entities $300,000. Okay, so can the creditors? There's only $200,000 in my estate. That's all I've left. But I actually owe $300,000. So what happens? Well, the creditors can take they can take the entire value of my estate, $200,000. That means there's nothing left for my beneficiaries. So my beneficiaries, no matter what I put in my will, my beneficiaries will get nothing. But can the creditors then, like the banks and stuff, then go after my beneficiaries, let's say, for the extra $100,000 that wasn't in my estate, but that I owed? And the answer is, in most cases, no. So in most cases, the creditors are going to have to settle for what was in the estate, which is $200,000, and they'll take that money, but they can't get any more because that's all that was in the estate. And they can't go after your beneficiaries for the additional money. Are there any exceptions to that? And the answer is yes, there are. So there are certain situations where your beneficiaries, or people you know who aren't beneficiaries, might actually have to pay money above what they would inherit from you. In most cases, they only have to pay to the limit that they're inheriting. So they don't lose any of their own personal money. They just lose their inheritance. But there are exceptions to that. For example, if you took out a loan which you co-signed with someone else, whether it's a beneficiary or not, the co-signer is completely liable for the balance of that loan when you die. So, for example, let's suppose I took out a $300,000 loan before I died. My estate's only worth $200,000. So when I die, the bank's going to take the $200,000, but there's still going to be $100,000 owed on that loan. And so whoever I co-signed the loan with is going to owe that $100,000, even though they got no inheritance from me, because that money was also taken by the bank. So in that case, yeah, the co-signer of the loan is fully liable for the full extent of the loan after you die, even if it's beyond the inheritance money. Also, if you took out debt from a joint account, let's say I have a credit card account where there's another person's name on the card. So there's two names on the card. And before I died, I bought a new car on that credit card and paid $50,000. So now there's a $50,000 balance on that credit card. Well, if I then die, the other person whose name is on that card owes that $50,000. And even if I only left them $20,000 in my will, the bank's going to come after them for the full $50,000 and can get it. So when something's purchased from a joint account, or there's a co-signed loan, then even after you die, the banks and the financial agencies can actually go after the other person who's on the account or on the loan for the full amount, even if it's more than they're inheriting. So they can go after their personal money. So those are exceptions to that rule that I talked about, where people are only liable up to the amount that they're actually inheriting. Another exception, California is what's called a community property state. It's one of 9 community property states in the country, but there are only 9 states like this. Community property may sound like a good thing, and in some cases it can be, but when it comes to inheritance, it's actually a very bad thing for your spouse. Community property involves spouses, legally married people, a legally married couple. It doesn't involve anyone else, not kids, not parents, not brothers or sisters. But certain debts that are incurred during a marriage are considered to be the debt of both people, fully, 100%. So for example, let's suppose I die and I have a $200,000 estate, which I leave to my wife. But before I died, I ran up, because I was very ill for months, I ran up a $300,000 medical bill. So can the hospital then, where I ran up that $300,000 bill, can they collect the $200,000 from my wife in the estate? Can they take her inheritance? The answer is yes. And they can go after her personally for the other $100,000. Because remember, I owe $300,000. Because in California, medical debt that's incurred by one spouse automatically becomes the responsibility of the other. In full, 100%. I know that's disturbing, but that's actually the law. That's what a community property state means. So that means that if you die with big medical debts, your spouse, your legally married partner, is responsible for that debt, 100% of it, even if it's more than the value of your estate. You're thinking, ouch, that's awful. And yeah, it is. but that's what it means to live in a community property state. So California is one of those. Most states are not. They don't have that rule. Now, one thing you should know is this community property only applies to spouses, legally married people. So if you are not legally married, or, if you're talking about a different relative, like a child or a parent, they are not responsible for that debt. So if I die with $300,000 in medical debt, and let's suppose I don't have a spouse, I'm not married. Let's suppose I have a live-in partner who I never married, and I have a child. And I left them both $100,000 of my $200,000. So the medical debt is a legal debt. It's a $300,000 legal debt. So the hospital can take the $100,000 from my partner, can take the $100,000 from my child, so they get nothing from my estate, but can't go after either of them for the additional $100,000 beyond the estate value, because my partner is not, I'm not legally married, so they're not my spouse, so they're not liable for the extra debt. And my child is also obviously not my spouse, so they're not liable either. So those folks may lose their inheritance in that case, but they would not be personally liable for the debt in the sense that the hospital couldn't go after them for, the additional money beyond what they were going to get in the inheritance. So hospitals can only do that if there's a spouse involved, a legal spouse. If there isn't, then the most they can collect is whatever the value of the estate is. Okay, so those are sort of the ins and outs. Bottom line is if you die with debts, the debts are satisfied from the estate value. And sometimes that actually involves, depending on the value and the magnitude of the debt, it might involve selling property. For example, let's suppose I die with $100,000 in cash and the property worth $500,000. But at the time of my death, I owed $200,000 to the bank. So the bank will take the $100,000 in cash, but then they're going to force the sale of the property in order to collect the additional $100,000. So my executor, my will have to sell my property for $500,000 and then give $100,000 of that to the bank too. But the remainder, the $400,000 that's remaining, can then be distributed to my beneficiaries. Okay, so the bottom line is debts follow you after death, up to the limit of the value of your estate, and in a few cases beyond that limit, depending on the specific situation. Okay, so how about some good news? That's a lot of bad news. Are there forms of inheritance that can't be touched by my creditors after I die? The answer is yes. There's three forms of inheritance that creditors can't touch. So even if you owe money at the time of your death, they can't take the money out of these pots. The first of these is life insurance. So for example, if I had a $50,000 life insurance policy and I've been paying the premiums on time and then I die, and let's say my named beneficiary on that policy was my wife, then she gets that $50,000 after I die and the creditors can't touch it. So they can't go after that specific pot of money. And that's because actually your creditors are your creditors. They're going after your money. The life insurance money that's being paid to your spouse isn't your money. It's actually the insurance company's money. So the insurance company is not liable for your debts. So your creditors can't go after your life insurance. They also can't go after your pension or Social Security benefits that you designate to your survivor. So most pensions and Social Security plans allow you to designate what are called survivor benefits. So if you die while you're still getting paid, you can designate a person or more than one person to receive some of your benefits after you die. Now you have to make this designation before you die. But if you do that, then the money that you've designated from the pension or Social Security cannot be touched by your creditors. They cannot go after that money. The final thing that allows you to sort of get around creditors upon death is any assets that you've placed in what's called an irrevocable trust. Now we'll talk more about exactly what that is in the next video. But if you place some of your assets while you're alive in an irrevocable trust, the assets that are placed there cannot be touched by creditors. They go to whoever you designate in the trust, your beneficiaries, and creditors cannot touch those assets at all. The reason for that is technically after you've created an irrevocable trust and put something in it, you no longer own it. The trust owns it. And so your creditors can only collect debts from you, not from your trust. Now there's another kind of trust, again we'll talk about more of this later, called a revocable living trust. And stuff you put into this trust while you're alive can't be touched by your creditors while you're alive. So there is some protection there from creditors, even in a revocable trust. But anything that's in a revocable trust becomes fair game for creditors as soon as you die. So a lot of people misunderstand this when they're setting up trusts and wills. They think that one advantage to a trust is if anything they put in a trust is going to be completely protected from creditors. And it's just going to go to their beneficiaries. And that's not true. Most trusts are revocable living trusts. More than 90% of trusts are the revocable kind. Irrevocable trusts are actually pretty rare. So if you put stuff in a revocable trust, which most people do, it's true that creditors can't go after it while you're living. So while you're alive and it's in that trust, your creditors can't touch it. But as soon as you die, they can. They go after it and they'll take it legally. So it won't get to your beneficiaries. Okay, so it's very important when you set up wills and trusts to understand the difference between, if you're doing a trust, between a revocable trust and an irrevocable trust. They're quite different and they have very different consequences, particularly for what creditors can take from your beneficiaries and what they can't. If you have stuff in an irrevocable trust, creditors can't take it from you or your beneficiaries. If you have stuff in a revocable trust, creditors can't take it from you while you're alive, but they can take it from your beneficiaries. Okay, so hopefully that's addressed some common questions people have about stuff that happens after they die. Debt, I know, is a big question a lot of people have, and that's why I wanted to hit it in a lot of detail here. But hopefully I was clear enough that you could kind of follow along. I know this is pretty deep legal stuff and can be confusing. Keep in mind, I'm not an attorney and I don't pretend to be, so I'm just trying to give you some general information here which might be helpful. If you have specific, real specific questions about wills and trusts and inheritance, then you definitely should contact an estate attorney to get those questions answered. Okay, but I do hope this was helpful. So I'm going to do another video on estates and inheritance where I talk in detail about trusts and the different kinds of trusts and trust versus wills and probate and something called transfer on death accounts. And so we'll get into the weeds in more detail in the next video.